I was asked to comment on this video by News Now Houston. Here's the here's his claim. It's pretty threadbare. It doesn't list a whole lot. It says that it's an action for money damages brought under 1983. Awesome. 1988. That's for attorney's fees. Attorney's fees. And then it is also bringing stuff under the laws and statutes of the state of Louisiana. We don't know what, but maybe there's something. It does not list the. So this is a good little paragraph here. The action for money damages brought pursuant to 42 U.S.C. 1983. That's a great place to start, as well as the Constitution of the United States, which does not give you a tort action, and the state of Louisiana. The Constitution of Louisiana also does not give you any tort actions. The United States Code, well, there's 42 U.S.C. 1983. Which other ones, maybe? Could you tell us? The Louisiana Civil Code, again, unnamed what provisions. The revised statutes of Louisiana, again, unnamed provisions. I'm sure that he's hoping to that this attorney is hoping to find other things to tack into here, and so he's just painting in real broad strokes. I have a sneaking suspicion that this attorney is operating on hourly fees instead of operating on a contingency basis. That's just my gut instinct, because this isn't saying a whole lot. This complaint isn't saying much. We have various things like they're claiming unlawful detention, they're claiming unlawful arrest, they're claiming false imprisonment, they're claiming that that there was negligent issuing of police equipment, including identification vehicles and firearms, I believe. They're saying that Defendant Rufus Jones, who at all times was acting under his authority. So they say that Defendant Rufus Jones banned the complainant from Camp Beauregard and all military installations. Okay, are you ready for that? But they also say that at all times, material and present, Defendant Rufus Jones was acting within the course and scope of his employment with the city of the Pineville Police Department. So, if he was acting as in his role as a patrolman for the Pineville Police Department, somewhere in here it further says that. Yeah. Rufus Jones, here we go. Individually and in his official capacity as a patrol officer for the city of Pineville Police Department, banned David Warden from all military installations. If that sounds retarded to you, that's because it is in fact retarded. So this to me is a very weak complaint. It's not very well fleshed out, and I'm assuming that they are going to amend it once they get some discovery going on or something. I'm not entirely sure. It's just very weak. It's very loose. There's not a whole lot going on. Mr. Warden said they were going to add the U.S., the Army, I think, the Department of Defense, the Louisiana National Guard. I don't think that's going to work under 1983 because you can't do respondeat superior style claims under 1983. You have to prove that he would have to prove that the Army, the United States Army, was somehow creating a policy that the Pineville Police Department were enacting or otherwise directing them to do that. And that's going to be hard to do considering it wasn't an Army base. It was a Louisiana National Guard base. Again, with the Louisiana National Guard, you'd have to show that the Louisiana National Guard had a policy telling the Pineville Police Department to arrest people who were at that particular spot. Maybe that's at least a little bit more plausible than the U.S. Army and the Department of Defense. That's just going to be patently ridiculous. Good luck, have fun. They don't call it a demur. They're going to do a 12B6 on that, and their Department of Defense is going to be gonzo. You're not going to get them on that. Yeah, so there currently aren't those parties. So I know that Mr. Warden has said that there is an amended complaint. I don't think there is. Pacer doesn't believe there is. It does say that there was some sort of action. The docket was last updated, but I think that's the last time that Pacer checked. I don't think that was the last time that there was actual activity. I'm not entirely familiar with this. It looks like the last actual activity was this review finding on Sunday. Maybe just hasn't updated yet. I don't know. Anyway, yeah, it's pretty weak. But and then there's also the other issue with it. If you're going to claim unlawful detention, unlawful arrest, and false imprisonment, you're gonna have to actually get past that conviction. Your appeal needs to be successful. If you are convicted of a crime, that means that a court has held that a criminal court has held that it was proven beyond a reasonable doubt that there was probable cause for the arrest, which means that there was reasonable suspicion for a detention. And the criminal court has also found beyond a reasonable doubt that you committed a crime. So saying that there's false arrest, false imprisonment isn't really going to fly if you have a conviction. So it's just weak. I have always maintained that Mr. Warden's arrest was very weak sauce. I don't think it should have flown. I think now that he has an attorney, if that attorney is successful in getting the appeal and successful in defending against the prosecution in the appeal, that or successful petitioning. I don't know if it's going to be a de novo. It's probably going to be a de novo, but I don't know entirely. So if it is entirely de novo, then he would have to be just successful in defending against the prosecution. If it is a review, then he would have to successfully petition for overturning the original court's decision. So I'm not sure which way it's going to go. That's a procedural thing for Louisiana that I just don't care enough to figure out. I'm sure Mr. Warden will, or his attorney, I should say, will figure it out and do the appropriate actions. So there you go. I hope you enjoyed it. Thanks for watching. Have a great day.